good day to everyone. I'm looking forward to the time, as you are, when we can all be together to discuss these really interesting topics. I am in my San Francisco courtroom, and behind me is the jury box where I would impanel a jury to try criminal defendants, including those who are charged with antitrust crimes. I'm going to discuss with you today the tools that I use and that other federal judges use throughout the United States to determine how an antitrust defendant as an individual will be sentenced. As you know, criminal antitrust fines and penalties against corporations can be sizable. If you look, for example, at page 6 of the slide deck, as recently as 2015, the Department of Justice collected $3.6 billion, that's billion with a B, dollars in criminal fines, and I know overseas agencies do similar work. It has been more of a challenge to deal with the prosecution and sentencing of individuals, and here is why. One of the main factors that affects the number and extent of sentencing of individuals is the fact that many cartel participants are not United States citizens or not within the territorial borders of the United States. They are, in my experience, and as far as I know throughout the United States, often overseas nationals beyond the reach of federal prosecutorial powers. On the rare occasions when those individuals are either American citizens or within the territory of the United States for prosecution, we would engage in the following basic steps to fix their sentence. Our first and foremost rule are the factors that Congress has required us as sentencing judges to take into account when determining the sentence for any individual before us, including antitrust violators. Those are at 18 United States Code section 3553, and you'll find those on page 2 of the slide deck. In essence, this is a guideline that requires us as sentencing judges to ensure that we impose a sentence that is sufficient but not greater than necessary to punish the individual, protect the public from future crime, and deter criminal conduct both by the individual and by others. A very critical part of sentencing in the United States is also in section 6 of section 3553. And that says that we are to give very careful attention to avoiding unwarranted disparities between similarly situated individuals, which means we need to make sure that when people are convicted of the same crime in similar circumstances, they get a similar sentence. If their sentences are wildly different, then serious questions can be raised about fairness and due process. Once we get to the starting point with section 3553A, we turn to what's called the Sentencing Guidelines. And you'll find those on page 3 and 4 and 5 of the slide deck. Now, the Sentencing Guidelines are put out by a national committee called the Sentencing Commission. They are advisory. They do not tie the hands of me or any other district judge. Nevertheless, in exercising our discretion, we always turn first to what the guidelines say. In a nutshell, the guidelines are a very complex, numbers-based approach to determining what a potential sentence should be. If you turn to slide 4, for example, you'll see the basics of how it works. The first thing we do is determine an offense level, which is on the left-hand side of that chart, an offense level that the individual is scored with, and then we tie that to a prior criminal history record, which is at the top of the chart. And that yields the numbers in between, which are the ranges of sentencing. Now, for the antitrust crimes, we in the United States, rightly or wrongly, have taken a position that the volume of commerce affected by the cartel violation is a very significant factor in determining the length of custody. So if you turn to page 5 of the slides, you will see the sentencing guideline at section 2R1.1, which provides for the offense level with respect to the volume of commerce affected by the price-fixing conduct. It is striking that the offense level goes up rapidly as the amount of dollars that are affected by the cartel go up as well. And by the time you get to the very bottom category, which is an offense level of 16, the amount of potential time in custody has increased tremendously. After that, we then tailor the sentence specifically to the individual before us. And we do that through a variety of means, including a very important report called the pre-sentence report. The pre-sentence report is prepared by the United States Probation Office for each and every defendant, and it contains, if we're able to get it, a substantial amount of information about that defendant as an individual. It includes, for example, a description of the individual's life and personal circumstances, what his family situation is like today, what it was like when he was growing up. Was he subjected to any abuse or mistreatment, or did he have a perfectly fine upbringing? It looks at prior criminal history, whether it was a conviction or just a charge. It's very comprehensive. It looks at the defendant's medical and psychiatric condition and flags any situations medically or psychiatrically that might need special attention. It looks at the history of the defendant with respect to alcohol or substance abuse. And it also recommends, again, a non-binding suggestion to me as the sentencing judge, what an appropriate disposition might be. Now, it's also important to know in the United States, the defendant is an active participant at each and every stage of these proceedings. The defendant files a memorandum giving his or her views of what an appropriate sentence will be. The memorandum comments on the pre-sentence report, often objects to it if they believe it was unfair or overstated with respect to example for prior crimes. And it also gives other information that the defendant would like me as the sentencing judge to take into account. I'll give you some example of that. It is very common for defendants to raise personal health issues, situations involving their families, medical situations for spouses and children, personal circumstances that make it impossible to pay a fine, and so on, when they are approaching me for sentencing. A very important part of sentencing here also is the defendant's statement during the hearing. It's called the allocution. It's something that I put a great deal of emphasis on. I'd like to hear directly from the defendant and why that defendant thinks the sentence that he or she is proposing is an appropriate disposition in that case. I take all of that into account and come out with what I hope to be and aim very hard to be a just and fair sentence. Now, as you'll see on page, I believe page 6 of the slide deck, the average amount of custody time in the United States is about 18 to 20 months for antitrust, cartel, and price-fixing behavior. My own sentences in that area have been in accord with that national standard. I would like to close with one thought, and that is an open-ended question. I'm not expressing any views, but I think it's important for us to look at whether sentencing individuals is having the type of deterrent effect we hope that it will be. I have seen in my own courtroom, for example, in my cases where I have sentenced individuals for price fixing, situations where the company at which they worked have kept the job open for them and have paid their salary while they were in custody. And then after they were released from custody, they returned to full employment with the company. In effect, the company excused the criminal conviction that they sustained. I think a question can be asked whether individual jail time, as significant as it is, there's no doubt that deprivation of liberty for even a day is a major experience. Is this enough to be an incentive and a deterrent to future criminal conduct, both by individuals and by their employer companies? Some commentators have suggested a debarment rule, a rule that would bar the convicted employee from holding a job for a certain period of time where they might be able to engage in an antitrust violation again or facilitate antitrust crimes by others. Now, this has not, to my knowledge, been used ever in the United States, and there are a number of issues that could be problematic. For example, we have a very strong practice and commitment in the United States to balancing and proportionality in the sentence. It would be wrong to impose a debarment that effectively foreclosed any gainful employment by a defendant and left them unable to work. On the other hand, I understand that there is some good argument that can be made that debarment may be an additional and necessary, possibly, next step in ensuring that individual deterrence has the effect that we hope that it has. Thank you very much. Looking forward to seeing the other interventions.